Hello and welcome everyone to our webinar on Mastering Workplace Safety, your consultation obligations. We're so glad that you can join us today. My name is Dickson Wu and I'm a senior lawyer in LegalVision's Employment and Work Health and Safety team. And I'm joined by my co-host Gurpreet Sandhu, who is a lawyer in the team. Now, before we begin, I'd just like to flag a couple of quick housekeeping items, just so you're aware, firstly, that you're going to receive a copy of the recording and the slides in your email. Secondly, we're going to have a dedicated time of Q&A at the end of the session, so feel free to submit your questions throughout the course of the presentation, and we'll try our best to answer them at the very end. Thanks to those who also submitted questions before the webinar, we'll also try to get to those ones as well. Finally, we have a feedback survey at the end of the webinar, which we'd really appreciate if you could fill out and complete for us. It's always really useful to get your feedback on what you found useful from these webinars and how we can improve them as well. As part of that survey, if you're interested, you can also provide your contact details. And if you do that, you'll be eligible, or you can express your interest for a free consultation with us, discuss how we can help your business. That offer is available for the next 48 hours. So again, if you're interested, you can just include your contact details in the survey. All right, so we're going to be discussing managing workplace health and safety, and specifically your consultation obligations. So some of the things that we're going to be covering today include, firstly, understanding your legal duties under WHS laws, considering the right times to consult with your workers. Thirdly, knowing when to engage with other types of duty holders, as well as providing you with hopefully some very practical and useful tips for effective consultation. And then, as I mentioned, we'll have a time of Q&A at the very end. So I'm now going to hand it over to Gurpreet to kick off for us with discussing the legal duties under WHS laws.
Thanks, Dickson. So it's really important to understand and comply with your work health and safety obligations in order to create a safe and positive workplace, as well as to avoid penalties for breaches of your obligations. Now, as a quick side note, we'll call work health and safety WHS moving forward in this webinar. So before I get into the specifics of your WHS obligations, it's helpful to start with some background on how WHS laws operate in Australia. So historically, each state and territory had their own WHS laws, and this created some difficulty for businesses to understand and manage their obligations, especially if they were operating across a number of different states. So to develop consistencies in WHS laws across Australia, Safe Work Australia developed the Model WHS laws in 2011. All states and territories have implemented these Model WHS laws, except Victoria. Now, in practice, while there are some differences in Victoria's WHS laws, notably that they still use the term occupational health and safety, the WHS obligations are quite similar, which means our webinar today will still be relevant to workplaces and workers in Victoria. Under the Model WHS laws, there are 3 key duty holders who each have differing duties with respect to consultation and ensuring the health and safety of anyone in the workplace, being 1, persons conducting a business or an undertaking, otherwise known as a PCBU. Secondly, officers of the PCBU, and thirdly, workers. Now let's consider each of these duty holders and their duties in further detail. So to start off with a PCBU, the term PCBU is very broad and essentially covers any kind of business. Some common examples are sole traders, companies, partnerships, or associations. A PCBU has the primary duty of care to ensure, to the extent that is reasonably practicable, the health and safety of anyone in the workplace. Practically, this means things like providing and maintaining a safe workplace, ensuring adequate access to facilities, monitoring the health and safety conditions of the workplace and workers, among others. It's also really important to remember that this duty does not just apply to physical risks, but also to non-physical risks, and this can quite easily be overlooked. Accordingly, you may need to consider non-physical risks, which may impact a worker's mental health, and take steps to ensure their health and safety in this regard. For example, you will need to effectively manage any bullying issues or ensure that your workers are feeling supported throughout their employment. Now, I'm sure you're all wondering, what does reasonably practicable actually mean? And how far do you need to go to comply with this duty? So you don't actually have to eliminate all risks. You only need to do what is reasonably practicable to ensure the health and safety of anyone in the workplace. Ultimately, what is reasonably practicable will differ between businesses based on things like size and their operations. For example, what is reasonably practicable for a small business will be very different to what is reasonably practicable for a large corporation. Some factors to consider when you're looking at what is reasonably practicable are: how likely is it that the hazard or risk will occur? How much harm could it result in? What options do you have to eliminate or reduce the risk? And specifically the cost of implementing these options, as well as your own knowledge of risk management. You should be looking at these factors together to determine how far your duty extends. Now, moving on to officers. An officer of the business is someone who has significant decision-making power in the business. For example, your senior managers or your executives. They generally make decisions that impact a large part of the business. Officers have a duty to exercise due diligence to ensure the business complies with its WHS duties. Again, what does due diligence actually mean? So this means your officers should ensure their knowledge on WHS laws is up to date, be aware of and understand the hazards and risks in the business, ensure that there are appropriate resources, processes, and reporting lines in place, and ultimately ensure that the business complies with its WHS obligations. It's really important to identify who the officers of your business are, as well as to work with them to help them understand their own WHS obligations. Moving forward to workers. Now, workers of the business do not just include employees, but they also include individuals such as contractors, apprentices, or volunteers. Workers must take reasonable care of their own health and safety and the health and safety of others in the workplace. This will generally involve your workers familiarising themselves and complying with relevant WHS policies, instructions, and processes, using equipment safely, and actively reporting and identifying WHS risks and incidents. Now, moving forward to consultation obligations. In addition, a PCBU has a duty to consult, so far as reasonably practicable, with workers of the business who are or are likely to be directly affected by a health and safety matter. Again, remembering that workers do not just mean employees. For example, a consulting company located in an office will have a duty to consult with all of its workers who are likely to be impacted by a WHS matter. This means it should be consulting with its employees, including any working remotely and any interns. The obligations will also extend to workers from another consulting business who will be joining in the office while working on a joint project. I'll run through some practical tips on effective consultation later on. However, just briefly, this consultation involves seeking and considering the views of workers in relation to the health and safety matter. Now, additionally, a PCBU also has a duty to consult, cooperate, and coordinate activities with anyone else who has a WHS duty in relation to the same matter, only so far as is reasonably practicable. This will apply where there are a number of businesses that have overlapping WHS duties, for example, where there are different businesses working on the same construction site. Complying with this duty generally involves working together as duty holders to ensure the health and safety of anyone in the workplace. Each business should exchange information and work together in a cooperative and coordinated way so risks are eliminated and minimised so far as is reasonably practicable. Let's think about what these consultation duties mean for the other duty holders of the business, being your officers and workers. Essentially, your officers will have a duty to exercise due diligence to ensure that the business is complying with its consultation obligations, while a worker should be complying and participating in the consultation processes. So why is it important to consult? Firstly, you have a legal duty to consult, as we've discussed. Secondly, effective consultation will assist you with meeting your duty to ensure the health and safety of anyone in your workplace so far as reasonably practicable. For example, through consultation, you may identify risks or hazards that you had not otherwise considered, as well as ways to manage these. Thirdly, a failure to comply with your consultation obligations can result in serious financial penalties being awarded against you. Now, recently in 2020, Safe Work New South Wales successfully prosecuted and fined a plumbing company $80,000 for failing to consult with a worker and failing to consult, cooperate, and coordinate with another duty holder, which ultimately led to a worker suffering a serious injury. I'll hand over to Dickson to discuss how you can identify the right time to consult with your workers.
Great, thanks so much, Gurpreet. So the first thing to say here is we really suggest taking a proactive rather than a reactive approach to consulting with your workers. Regular consultation is better than consulting only as issues arise on a case-by-case basis or when new equipment or systems are introduced, because it allows you to identify and fix potential problems early. Now, helpfully and worth noting as well, the model work health and safety laws actually identify specific matters that trigger the requirement for consultation. So we'll run through these together. Firstly, you must consult with workers when identifying hazards and assessing risks to health and safety. Now, an example of how you can achieve this is by regularly walking around the workplace, talking to your workers and observing how the work is done. You could also conduct a survey to give workers an opportunity to provide input and valuable information about work-related health issues. Next, you're also required to consult with workers when making certain decisions. So these are decisions about ways to eliminate or minimize those risks that have been identified, when making decisions about the adequacy of welfare facilities. Now, these are facilities provided for the welfare of workers, such as toilets, drinking water, washing and eating facilities, changing rooms, personal storage, and first aid. Also, when making decisions about various procedures, such as steps to be followed when or for monitoring workers' health and workplace conditions, and providing information and training for workers. You're also required to consult with workers when proposing changes that might affect the health and safety of your workers. Now, some examples of when consultation may be required include when you're proposing to change work systems, such as shift work rosters, work procedures, or the work environment. It could be when you develop a new product or plan a new project, or it could be when you purchase new equipment or use new substances in the workplace, or when you restructure the business. To give you an example of this in practice, and we've taken this from a code of practice from Safe Work Australia on the topic of consultation. The example is that we've got a small cafe who routinely consults with staff about health and safety matters. The cafe owner and workers have agreed to a process of consultation that includes discussions during morning briefings, which occur during work time before the busy service period. The owner also talks to workers who undertake specific tasks when doing risk assessments of those duties and when considering the purchase of any new equipment that the workers will operate. The owner also consults with workers to get their views when it was planning updates to the staff room and locker facilities. So hopefully you see there just an example of how a business and a business owner can be considering and effectively consulting with its workers. Now that we've discussed the right or appropriate times to consult with workers, it's also important to remember that you also may need to consult with other duty holders, as Gurpreet mentioned earlier. So there are often situations where more than one business operates at a workplace and where people share responsibility for work health and safety to varying degrees. For example, in shopping centres, construction projects, labour hire, and multi-tenanted office buildings. The model WHS laws require that where more than one person has a duty for the same matter, each person retains responsibility for their duty in relation to the matter and must discharge the duty to the extent that they can influence and control the matter. So in these situations, each person with a duty must take reasonable steps to consult, to cooperate, and coordinate activities with all other persons who have a WHS duty in relation to the same matter. So talking to and cooperating and coordinating activities with others who are involved in the work or things associated with work will make the control of risks more effective and assist each duty holder to comply with their duty. It can also mean that health and safety measures are just more efficiently undertaken. So to give you an example here, you may not need to provide toilet facilities for your workers if they're already available, but you should check that those facilities are in good working order, that they're clean, and that they're accessible for your workers. Consultation, cooperation, and coordination between you and the person providing those facilities will help you ensure that the necessary steps are being taken so you can meet your duty. On the timing aspect of this, what is reasonably practicable for consulting, cooperating, and coordinating activities with other duty holders will depend on an objective consideration of the circumstances, including the nature of the work and the extent of the interaction. So, for example, two contractors who are working together may engage in direct discussions and planning as part of their everyday work. So they might have a regular meeting at the beginning of the day, whereas the owner of a large shopping center may need formal mechanisms with the retail businesses, for example, written agreements and consultative committees. Now, you should start consultation with other duty holders when you become aware they are or will be involved in the work. Usually, this is pretty apparent from the circumstances, whether through your contractual arrangements, their presence on site in the workplace, or the need for others to be involved in the work. You should also consider and identify who else may be involved in the work, maybe in the future, and so making contact with them and starting discussions with them as soon as possible, and as soon as it's reasonable to do so is a good idea. Now, this may occur as part of contractual negotiations and discussions when you're engaged to carry out the work, or when you engage someone else, another business, to carry out work for your business. Consultations should be taking place during the planning of the work to ensure health and safety measures are identified and implemented from the start. There may be need for further consultation, such as when the circumstances change over the period of the work, such as the work environment and the people involved in the work. And this is particularly likely in construction and other long-term projects. Ultimately, cooperation, coordination, consultation with other duty holders should be an ongoing process throughout the time in which you are involved in the same work and share the same duty. So I'll now hand back over to Gurpreet to discuss some practical tips for effective consultation.
Thanks, Dickson. With all of this in mind, how can you engage in effective and meaningful consultation? We've put together a few practical tips that align with your consultation obligations under the model WHS laws to help you with the consultation process. To promote a worker's participation in the consultation process, you can consider implementing a WHS policy, which requires workers to meaningfully participate in WHS consultations. This policy will also assist you with meeting your general WHS obligations. A WHS policy should outline the obligations of the different duty holders, such as the business, its officers and workers, as well as the business's consultation processes. Before you begin consulting with your workers or other duty holders, you need to remember that the key to effective consultation is that it is a two-way process. So, what should you be doing? Firstly, you should share all relevant information so that your workers or other duty holders are able to genuinely provide their views on a WHS matter. You should ensure that they are provided any relevant information as early as possible in a concise and easy to understand format. They should also be kept informed of any relevant changes. You may need to consider how to best communicate with your workers or other duty holders. For example, workers with limited English may find it easier to communicate through a health and safety representative. Secondly, you should be providing everyone a chance to express their views. You need to ensure that everyone is given a reasonable and real opportunity to express their views and opinions. You can do this by creating a calm and open environment in which everyone is comfortable to put forward their views. It's really important that you're accommodating during the consultation process so that everyone is given a real opportunity to consult. For example, you could schedule any relevant meetings at a suitable time for your workers and/or other duty holders. And where this is not possible or based on preferences, you could allow consultation to occur in a different format, for example, via email. And you should ensure that you include any health and safety representatives in the consultation process. Thirdly, you should genuinely consider everyone's views. Effective consultation requires genuine consideration of any views put forward, especially any alternate or challenging ideas. Now, this doesn't necessarily mean that you have to agree or comply with every request put forward. It simply means that you should consider the merits of any views raised during this process. You should be careful not to dismiss another person's views immediately. And remember, you may need to ask follow-up questions or clarify points raised during the consultation. And finally, you should communicate the outcome to all relevant parties. So following any relevant consultation process, you should be transparent with the outcome and the reasoning behind the decision. Now, in addition to consulting, you also have a duty to cooperate and coordinate activities with other duty holders. Of course, part of this involves engaging in effective consultation, but you also need to be cooperating with other duty holders. Ultimately, you should be engaging in an open exchange of information, open communication, and be willing to take steps to assist other duty holders in meeting their WHS duties. Moreover, you should be coordinating activities with other duty holders to ensure that there are no gaps in health and safety for anyone at the workplace. Again, remember that this duty only applies as far as it is reasonably practicable to consult, cooperate, and coordinate with other duty holders. So you may need to consider business needs, operations, and the participation of other duty holders in this process when determining how far this duty extends. It's also best practice to keep records of any consultations with your workers and/or other duty holders. This will help you demonstrate compliance with your WHS obligations. Now, that concludes the main part of our webinar. I know we've gotten through a lot of really useful content today, and to help you with meeting your WHS obligations, you might find our publication useful called Safety Essentials for SMEs. You can download this publication by scanning the QR code on your screen right now. You might also be interested in our upcoming event on the topic of attracting and retaining top talent, legal strategies for small businesses on Tuesday, the 6th of August at 11 a.m. Again, you can register using the link on your screen. So we're going to talk through and answer your questions shortly. While you submit them, we'll take a minute to tell you about LegalVision's membership. By becoming a LegalVision member, your business gets unlimited access to our full team of over 100 specialist lawyers for all of your business as usual legal needs. It's like having your own in-house counsel for a fraction of the cost. Our team can assist you with unlimited document drafting and reviewing of business contracts, unlimited legal advice consultations, and unlimited domestic trademark registration, and much more. We also offer a dedicated service for in-house teams and general counsel to manage your high-volume business as usual legal tasks. Our lawyers invest upfront in understanding what's important to your business and work as an extension of your in-house legal function. To learn more about how membership or desk extension can help you, request a free consultation when the survey appears at the end of this webinar. So we'll now move forward to answering some of your questions. What I might do is, it looks like we've got a few questions in relation to remote workers, so I'll combine all of these together. So the question is, how work health and safety, specifically consultation obligations, apply to remote workers, and any information on managing psychosocial hazards. So I'll hand over to Dickson to answer that question.
Yeah, thanks, Gurpreet. And yeah, really good questions that have come through around remote workers, those who are working from home. And I know a lot of what we covered, the examples we gave were cafes, construction sites, labour hire, but really important to remember that these duties apply to businesses who have 100% work from home arrangements as well. So the first thing to say here is everything we've discussed still applies, in that you still have a duty to take reasonable steps to ensure the health and safety of workers who are working remotely or working from home. Again, the big principle and the big question of what's reasonable in the circumstances will come into play. And ultimately, in light of that, what the law is requiring you to do is not necessarily be there to sit next to your worker while they're working from home to make sure that they never injure themselves. But there is still that requirement, that duty to be taking steps that are reasonable. So an example here could be to provide or require workers to complete a working from home checklist, which will ask them a series of questions about their work from home arrangement and setup, and make sure that everything's adequate and safe moving forward. So, examples would be, they're working from a proper desk, everything's at the right height. They're working from a proper chair as well. There are no cords lying around on the floor that they might trip over. Is there good lighting in place as well? So that's just one example there. Now, in terms of actually consulting with workers, and worth remembering, as Gurpreet mentioned earlier, that we're not solely focused on physical risks to health and safety when we're thinking about work health and safety, risks and hazards. There's been a big shift and a focus on psychosocial hazards, so non-physical risks to health and safety. And so where we have a worker who's working from home 100% of the time, there may be limited physical risks to health and safety. Maybe they'll get a bad back or a bad neck from sitting down, looking at a screen all day. But what we're seeing more and more are risks associated with, say, bullying, discrimination, and harassment. It could be from not receiving enough support. It could be poor change management, or it could just come purely from the fact that they're working very isolated. So if they're working on their own without much interaction with other people, that can be a source of risk as well. So in terms of consultation, again, it's just about taking reasonable steps. And so it really depends on the nature of your business and your operations. But say if you had regular meetings with your workers, whether that's on a daily or weekly, fortnightly basis, that's just something in terms of work health and safety that you can put on the agenda. And it could be the case that everything is the same, everything is normal, there are no changes to work conditions, no changes to the systems and the way that you do things. And if so, then there might not be much that is raised. But again, giving opportunities for workers to express themselves, whether in a team context or in more a one-to-one context as well. That can all really help. Firstly, with you complying with your consultation obligations, and secondly, to give workers or your employees an opportunity to express any concerns or ideas that they may have as well. So hopefully that answers your question in terms of what to do about remote workers, those who work from home. It still applies to them, but that principle of taking reasonable steps is what's at play here.
Awesome. Thank you for that, Dickson. That's super helpful. So I've got another question come through there as well. And the question is, do I always need to consult with all of my workers?
Yeah, really good question. So remembering, again, coming back to the duty, it talks about consulting with workers who are going to be affected by that work health and safety matter, or likely to be affected. And so the answer to this is, you don't always need to consult with your entire workforce, your entire team in relation to work health and safety matters. An example I can give here is if you decide to purchase a new piece of equipment, but that piece of equipment is only going to be used by certain members of the team, or it could be reasonable that only those members of the team are the ones who you consult with, as long as it's not affecting other members of the team as well. So yeah, that's the answer to that. Not the case that you have to consult with everyone all the time. That in fact might be very onerous, particularly if you've got lots of staff members. And so again, take those steps, consider what's reasonable, give workers an opportunity to express their views as well.
Perfect. Thank you so much for that, Dickson. So another question that's come through in relation to consultation obligations with regards to labour hire companies. So the question is, labour hire companies in New South Wales don't fully understand their obligations on what they need to do to place people in construction sites. So the question is what they need to do. So consultation can be an issue in this type of business, particularly where you have people spread over a different state.
Really good that you're thinking about this in the context of labour hire. So this is an example of where there are going to be multiple duty holders who may need to consult, who also need to coordinate activities with each other as well. So the way I'd start answering this question is by saying that in terms of the labour hire company, there are still obligations and duties on the labour hire company, even though they're going to be hiring out their workers or placing them elsewhere, such as on those construction sites. But again, we come back to what's reasonably practicable. So examples here could be, well, are we ensuring that we are hiring people with the adequate skills and training for the particular job? Is there any requirement of actually training them beforehand, before they even get to the construction site, on safe ways to perform their duties? Again, this might be pretty limited in what the labour hire company is able to do. But then once we get to actually placing them on the relevant workplace, such as a construction site, that labour hire company can consider putting obligations on the host, on the operator of that site, this could be through the contract to ensure that they're complying with work health and safety obligations as well. That could include ensuring that once these workers go on site for the first time, that there is an induction that's taken place, so that they're aware of any risk to health and safety. If there's any PPE that's necessary as well, ensuring that that's all adequate and provided and being used. And ultimately, this could just involve some consultation with that duty holder. The labour hire company often has very little or no control over the construction site itself. So again, it's that business who will have their own duty there. But again, it's a lot of this is about working together, being aware of that you still have an obligation, but to just be taking reasonable steps to discharge those duties. Now, of course, there might be in the context of a construction site, just more specific requirements that may be needed as well, in terms of, say, any licenses or safety checks and things like that. So again, it's about checking whose responsibility it is to ensure that those workers have those necessary, say, licenses even before they go on site. And is there a checking process before they are able to enter the work site as well? So that's a fairly high level overview to answer that question. But hopefully that helps as a starting point in terms of, firstly, just acknowledging and understanding that there are multiple duty holders at play here, and each with their own responsibilities, but also with a responsibility to work together.
Awesome. Thank you so much for that, Dickson. Another question that we've got come through, and this is more, I think, in relation to national organisations. So how can a company actually receive notifications about changes to legislations in their state?
Yeah, so if you'd like to keep up to date with changes to the law, a really good starting point would be Safe Work website. You can subscribe to their newsletters and their updates, and that's Safe Work Australia. And then there's also the kind of relevant Safe Work equivalent in each state and territory as well. So yeah, that can be a really good starting point. Of course, if you would like some more, in a sense, tailored assistance as well, that's something that we can help you out with in terms of, we've got a specific work health and safety advisory service. So if you've got specific questions, we can help you with that. We also, as part of that service, provide regular updates in the form of a short newsletter on any relevant changes to the law as well. But for now, as a starting point, the Safe Work Australia and kind of equivalent state and territory websites are a good place to begin. All right, well, just having a look at the Q&A box, and it doesn't look like there are any more questions at the moment. I'll give another, say, 15 to 30 seconds in case there are any final questions. Otherwise, we'll look to wrap up. So if you have any burning questions or anything final in relation to work health and safety and consultation, feel free to submit them now. Otherwise, we'll look to wrap up. Okay, well, if there are no further questions, then we're just going to wrap up there. I've actually seen a question about to pop up, but we're just going to wrap up there. Sorry if we haven't answered all of your questions, but again, there's that opportunity to submit your details in the survey at the end. If you want to have a chat about that particular question that we couldn't get around to, and how we can help your business through our membership as well. And even if that's not the case, feel free to, and we encourage you and appreciate if you can fill out the survey, again, just so we can get your feedback on how we can improve these webinars and make them as helpful for you as possible. So thanks very much for joining us, and I hope you have a great rest of your day.